Hi, my name's Amber Cowell, and today I'll be giving my special issues in law presentation. To start this presentation off, I'm going to go ahead and switch this and share my screen over to my presentation. So as I stated, this is my special issues in law presentation. My name is Amber Cowell. All the photos that are in this presentation were taken by me on behalf of the Culver Park Department. I'm going to start out by answering the first question: what legal issues are trending in the setting and/or field you're most interested in? So today I'll be focusing on negligence, specifically negligence within the lifeguard position. I am focusing on this specific issue because a lot of recreation directors like myself have to deal with waterfront property or a pool and hire on lifeguards annually. And they need to understand both the lifeguards and the facility operator or manager need to understand the risks and how they may be liable for negligence when taking on these responsibilities. So what is the issue? Specifically, the issue is the lifeguard position and their duty to act. When lifeguards are on the stand, they are taking on the responsibility, the primary responsibilities of a lifeguard. When doing so, they need to perform their tasks adequately, otherwise they can be fined negligent because they are seen as an emergency service responder. Why is it important? The reason this is important because oftentimes lifeguards, and as I said, operators and managers of these facilities need to be aware of how they can be negligent. A lot of times people don't understand and think it's on the lifeguard. However, as I've learned in the research of these cases, that oftentimes the manager is found liable for negligence. So the three cases I'll focus on are S&C Company versus Horn, Jung versus Village of Ridgewood, and then Morales versus Asteries Matters Community. So for this first case, I'll provide the description. This took place at an apartment complex. There was a landlord owner of this specific apartment complex. Unfortunately, there was a victim, 14 years old, that fell victim to the drowning case. On this day, the lifeguard was admitted to being distracted by conversations with friends. And this kind of gets into the theme of negligence and how the lifeguard wasn't performing their responsibility adequately. However, this case did take a turn, and who became liable ended up being the landlord owner. The child had drowned. The lifeguard admitted to seeing the child 5 to 10 minutes before the drowning and had to be made aware of the submerged body by another patron. Once the lifeguard was made aware of the situation, they did act because they did have a duty to act. This relates back to our text, and on page 40, the text describes duty as a responsibility toward others to protect them from unreasonable risk of injury. Once the lifeguard had discovered there was a situation in injury occurring, they did react. So their duty to act once aware of the situation was covered. And then unfortunately, it was found that the environment which the lifeguard was expected to survey wasn't ideal for a rescue situation. The water was murky. The stand at which it was positioned, the lifeguard stand and how it was positioned wasn't ideal for surveying. And then last it was discovered there wasn't the proper equipment to provide resuscitation. So ultimately, the landowner was found negligent in not providing the lifeguard with the proper equipment to respond to the emergency situation. The next case, Jung versus Village of Ridgewood. This specific case took place in New Jersey. There was a family visiting from Korea, the So family, and the son, Jung, had drowned in this situation. There were 9 lifeguards on duty at the time, and the first thing, once again, that came into question was the lifeguards in this case responding appropriately to the situation. Ultimately, it was discovered that once again, the way that the surveying zones, the zone of coverage, which were definitions provided by the American Red Cross, were not adequate for making a save or surveying the area. Ultimately, the jury awarded the plaintiffs a total of $10 million, and that was all monetary compensation for the pain and suffering that the So family endured. The third case was the Morales versus Asseries Matters community. This case took place at a YMCA, and what occurred was there was a lifeguard directly in front of the victim that had drowned. They had suffered a seizure, and he was in the water for over 5 minutes before a patron advised the lifeguard about what had occurred. Ultimately, the lawsuit alleges that the YMCA failed to maintain lifeguard stations that provided clear, unobstructed views of the pool area, and that the lifeguards failed to pull the victim, who was Bornstein, from the water when they knew or should have known that he was in distress and underwater. At the time, the 2 lifeguards were manning the indoor pool at the time of the instance, according to the attorney. The YMCA ultimately was the ones that were found guilty in this case again. So focusing on the case conclusions, how can what you learn be applied to your selected setting? For me specifically, we take water safety and training very seriously. And honestly, the reason I had always done that was because I cared very deeply for our lifeguards. When taking a lifeguard class over 5 years ago, a lot of times in a specific section was focused on negligence. At the time, I didn't fully understand it. I was always concerned because I knew lifeguards could be sued for millions of dollars. As a manager, I didn't want that ever to occur for my specific lifeguards. However, once looking deeper into these 3 cases, I discovered that as a manager, I am equally responsible for the people that I hire and the conditions in which I put them in. So what recommendations would I make for professionals working in this setting? I would say understand the risks and understand that you are also negligent. In all 3 of these cases, SNC Company versus Horn, Village of Ridgewood versus Jung, and then last in the Bornstein case, the facility operators in the specific facility were all negligent in these cases. You must understand the standards set by the American Red Cross. And my suggestion would be to take on these certifications as manager, facility operator certified, water safety instructor certified, lifeguard instructor certified, so that you can adequately understand what you need to set your lifeguards up for success. So like I said, I had always had my lifeguards in mind when I provide them with the adequate environment to respond to an emergency situation. I was shocked during this research for this presentation about how basically the employer of a lifeguard can be sued as a result of a legal doctrine, which we had looked into in the class, which is respondeat superior, also called vicarious liability. And in the text, they describe it as this legal rule, which means that employers can be held responsible for the actions of their employees when, 1, the employee is acting within the ordinary scope of his or her employment, and 2, as a result of employees' wrongful actions, someone is injured. So basically, an employee of lifeguards, there's a massive amount of responsibility put on these lifeguards, but even more so for the managers and operators of these facilities. So understanding these specific things, not only for the lifeguards who we hire and care deeply about, but understanding personally as well, as a manager or operator, that you are just as liable for these specific situations, which was a totally new concept to myself. So I was really happy to look into it and understand these implications. And here are all the sources as part of my presentation. I'm going to go ahead and take it off the stop share. But yeah, so thank you very much, and I hope you enjoyed the presentation. Thank you.